specialist with Texas A&M AgriLife Extension. I'm excited to be here today to talk to you about agriculture, estate, and succession planning. This is a topic that's really important to me because in addition to being a lawyer, I am a farm kid. My husband and I are raising a couple farm kids of our own in the Texas Panhandle, and this is really a topic that I think is important for everyone to be aware of, to be thinking about, to start taking action on, regardless of your age. So it's really easy to think, well, I'm in my 30s, we don't need to worry about this. That's really not the case. And so our goal today is going to be to give you some basic information, some things to consider, some steps to take to get the ball rolling on your estate and succession planning. So here's a roadmap of what we're going to cover today. We're going to start off with a musical introduction to the issue. Then we're going to look at what happens if you have nothing in place. I think there's a lot of misperceptions about what would happen if a person dies without a will. So we're going to talk a little bit about that. Then we're going to look at the probate process in the state of Texas and some potential alternatives to probate. And then we're going to walk through a 5-step plan to a successful transition of your farm, ranch, or agribusiness. So when I speak, I have to give a disclaimer that basically says I'm a lawyer, but I'm not your lawyer. So today I'm going to be here giving you a lot of information. I can't give you any specific legal advice. If you need that, you're going to have to hire your own attorney that's licensed in your jurisdiction. We're going to start off with a song by a country music artist named Corb Lund. I'm not sure who wrote the song, but I feel confident it must have been an agricultural lawyer. If you listen to this song, it's going to bring up so many of the issues with estate and transition planning that we're going to discuss today. So let's give that a listen, and then we'll continue on with our presentation. So for a lot of people, that song can feel a little bit like a punch in the gut, because I'll almost bet you that everybody here has either dealt with one of these issues or at least knows someone who's dealing with one of these issues. So let's talk about a few of these items. The first one is, if you listen to the song, the family didn't think much about the future. I think a lot of our families are pretty guilty about that, right? We're so busy with the day-to-day, the farming, the making sure we get everything harvested, making sure our pesticide applicator's license is up to date. It's easy to overlook this and put it on the back burner. They say they assume what they love would always be there. I think that's something else that we're pretty guilty about, is just assuming that because we love this, because our family's involved, everything will just seamlessly transition to the next generation. We'll see in a minute the statistics don't really bear that out. We see a brother who gave up college to help his dad at the ranch. Again, I think that's a story for a lot of farm families. That's the story for my own family. My father, his father passed away when my dad was about 13 years old, and he stayed home to keep the farm and ranch running, and he's been there ever since. We have a sister who left the farm and moved back east, so we're going to have an on-farm, off-farm air issue that's going to arise here, and that's another issue I know arises for a lot of families. Then dad dies, mom is old, and the brother is kind of left there to take care of things. The sister marries a city boy. It was a lawyer, but I try not to mention that part because it makes us look bad, right? And they had different ideas of exactly what the value of the ranch was. Both of them saw value, right? But the value the brother who stayed home and worked there day in and day out saw was very different than the value, the dollar signs that the off-farm kids may have seen looking at the operation. Would they end up in some sort of lawsuit where the brother gets half and the sister gets half of the operation, and the brother lacks the liquidity to buy her out? We say all the time that in agriculture, we are land rich and cash poor. And when you're talking about an estate and a succession plan, that can be a major issue, this lack of liquidity. The brother is forced to sell 20 sections of the ranch to a developer in order to buy the sister's half out. And if we think about how crazy this is and how difficult it's going to be for any farm to sustain that kind of a buyout, you're essentially buying the land twice, right? The first generation already bought it. Now the other generation's buying it again. It's really hard for that math to ever work. Then there's a line that we're going to talk about later that I think is one of the best lines in the song. Sometimes right isn't equal, sometimes equal isn't fair. We'll talk about that as we get into things here in a few minutes. And then at the end, the ranch couldn't generate enough income with the remaining land to pay the mortgage. There's a foreclosure, and this the brother, right, loses the family ranch that's been in the family for 5 generations. And that's something that is, it happens. That's also, I think, the pressure of that is one of the main causes we see a mental health crisis in agriculture, right? And again, if we can just take some of these simple steps that we're going to talk about today, our hope is that we can relieve some of that pressure. We can get people that are, to never be in that type of situation. And unfortunately, it's not just with the songs. So if we look at some of the statistics related to this, 55% of Americans have no estate or succession plan in place. That's a crazy number. And I wish I could tell you in agriculture we're better, but we're actually worse. 64% of farm and agribusiness owners have no estate plan in place. And when you look at this from the business succession angle, right, the ability for the family farm business to carry on, the statistics there are grim as well. Only 30% of family-owned businesses survive succession from the first to the second generation. When you look at the second to the third generation, it's 12%. And when you look at the third to the fourth generation, only 3% survive. And I think what these statistics should tell us is not having a plan is not working. And so we have to have some sort of plan in place that will allow us to set our heirs up for at least a fighting chance at making this succession something that is manageable and they can be successful at. So let's talk about what happens if you die and you don't have anything in place. So if you're one of those 55% of Americans that don't have an estate plan. And this is important because I think that there's a lot of misinformation out there where people think, well, it doesn't really matter if I have a will because if I pass away, everything will just go to my spouse. That's not how it works. If it was that simple, I probably wouldn't be here preaching at you. Instead, what happens is the government will essentially decide where your assets go. And they do that through what's called an intestacy statute. So all 50 states have sort of a statutory formula that just lays out where someone's assets go if they pass away without a will. And there's a couple of problems with that. Right? The first one is there's no family that's one size fits all. And so a lot of times when you look at how things pass through that intestacy statute, it doesn't make sense. It's not what anybody would want. It's not something that would really be feasible to make work. And again, that's just because you're stuck with this statutory formula. The second thing is it will make the probate process take longer and cost more money. So we'll talk about the probate process here in a minute, but if you don't have a will, essentially there's an entire heirship proceeding that has to be conducted by the court before you ever get to the probate process. So it just adds this whole separate layer of a courtroom type hearing and an investigation that has to happen. And again, that's going to cost money and that's going to take time that you probably don't want to waste on that type of expense. The other thing is the likelihood of disputes among the heirs increases. And again, that goes back to there's no family that's one size fits all. And what the intestacy statute does in a lot of situations is end up lumping people in as joint owners of property or of assets, and that may not make any sense given the family dynamics. So let's talk about sort of how the intestacy statute works here in Texas. If the husband dies without a will, so that's what we're going to use as our example here. Okay, so husband dies, no will, where does his property go? If we look at the example that's going to be on the left, that one is if the husband is married with no children, the statute says that his wife gets all of his separate personal property and half of his separate real property. So separate property is going to be any assets he brought into the estate or any assets that he may have inherited while they were married. All right, so she's going to get half of the separate real property, so that would be like land, and she'll get all of the separate personal property. The other half of the separate real property goes to the husband's parents, okay? and the wife gets all of the community property. So what I want to kind of hone in on there is, let's think about that separate real property. So if the husband inherited land from his grandfather, for example, and then he dies, that would have been separate property because it was inherited. And the intestacy statute says it's now owned halfers between the surviving wife and the parents, which means the wife and the mother-in-law now co-own the farm together. Does that strike anyone as being a good idea in all situations? Probably not, right? So that's an example of how this can be a problem. Let's look at our second example where it gets a little bit more complicated. If the man is married with children at his death, the wife is going to get 1/3 of the separate personal property and the children get 2/3. The wife also gets a life estate in 1/3 of the person's land, so a life estate in 1/3 of the land, with the remainder going to the children. And then for community property, the wife would get the husband's share so long as the children are all her descendants. If he had children from a prior marriage or with another partner, then the children would get his portion of that community estate. Let me sum that up for you. I want no part of anything that has that many fractions to figure out ownership, right? It's just a mess. And so again, the intestacy statutes are there. They are one size fits all, and you can end up with situations that are just a headache. And even a simple will that just said everything goes to my wife would avoid this statute. Okay? So let's look at another example of how this statute can be really problematic. I call this the second husband example. Let's say that you're married with no children and no will, and your grandpa left you his farm. Similar example as earlier. You die, right? And because that farm was inherited separate property, your wife owns half and your parents own half. And let's say after that your wife remarries and she comes to one of the corn producer seminars, hears me speak, and thinks I'm brilliant. And so she goes home and makes a will like I tell her to do. And who does she leave everything to in that will? Her new husband, right? And then when she dies, your farm, through the will, passes to her husband, and the second husband and your parents are now co-owners of grandpa's farm. Is that what anybody would draw out when they were making an estate plan? Probably not, right? So again, this is just simple examples of how it could really end up a mess if you don't at least have a basic will to sort of instruct where your assets need to go. So next up, I want to talk a little bit about the probate process. A lot of times when someone hears probate, they immediately have sirens and flashing lights going off and they think we have to avoid probate, right? You'll hear that. What can we do to avoid probate? Oh, we don't want to have to probate. We'll be stuck in there forever. We're going to lose all this money. There's a couple of things that I want to say here before we kind of talk through the process. One of those is that the probate process in Texas is relatively simple. If you lived in another state, like Colorado or California, those might be states where there is absolutely a reason to try to avoid probate at all costs. That's not necessarily true in Texas. Much simpler process, still a process, right? Still going to take time and money and kind of hassle, frankly. But it's not something that's just completely undoable or going to make somebody go broke. And what I will tell you is there are some instances where a person trying to avoid the probate process could spend more money on the tools to avoid it than they would have spent just probating a will. Okay? So there's no one size fits all here. I'm just telling you, probate's not necessarily something to be terrified of. And I would certainly want to talk with an attorney to determine, is there a reason for us to really try to avoid probate? What does that look like? And let's talk about the pros and cons of each of these options. All right, so let's talk through what the probate process is. Pretty simply, probate is just a court legally recognizing that someone has died and overseeing the payment of any sort of debts and distribution of that person's assets. right? So when someone dies, they own all this property and these assets in their name. There's got to be some sort of legal procedure to get that out of their name into somebody else's, right? That's what the probate process deals with. You want to keep in mind that the probate process deals only with probate assets. That's not something that I think a lot of people understand. That's not a term you may be familiar with. So let's talk about that for a little bit. Okay, so probate assets are essentially those assets that are going to pass through the will or through those intestacy statutes if there's not a will. Non-probate assets are going to be assets that pass contractually or by some sort of agreement outside of the will, right? So for example, when I started working at Texas A&M, I got a retirement plan. And on that plan, I had to designate who my beneficiaries are, right? That's a non-probate asset because that's going to pass by that contract I have when I designated the beneficiaries. What the will says is irrelevant, okay? So probate assets pass through the will, and generally that's going to be things like any separately owned property someone might have, any their portion of the community property that they co-own with someone, like as tenants in common. The non-probate assets that pass outside of the will are going to generally be things like retirement benefits, pension plans, life insurance policies. If you have ownership of property or bank accounts that are titled as joint tenants with right of survivorship, that would pass outside the will. Any sort of pay on death accounts, trust property, right, because it's held by the trust, and then any property that's passed by a transfer on death deed or a ladybird deed. And we'll talk about those in a few minutes. Okay, so just keep in mind that when we're talking about probate, that may not be all of your estate. And for some people, a substantial amount of their estate may be held as non-probate assets, right? If you think about somebody maybe who lives in town and only owns their house and a big retirement account from working at the school or whatever, they're going to have a much larger non-probate estate than a probate estate. Okay? So, the nuts and bolts of probate. In general, a probate needs to be filed within 4 years of the person's death. And this sort of depends on the person. There are some people that, the day after the funeral, they want to get rolling and get stuff done and they'll file it. There are some people that wait longer, or they may not realize that it was necessary to file the probate, and so it can drag out. But in general, it needs to be filed within 4 years of the death. Probate gets filed in the county where the person resided at their death. And that can be an important distinction, especially for some of us that live in rural Texas. If somebody, let's say I live in Carson County. Somebody may have lived in Carson County their entire lives, but at the end of their life, they moved to the nursing home in Amarillo, right, which would be Potter County. If they were living at that nursing home, then you're going to have to look at the facts to sort of see, but their residence may switch, and you'd file it where they resided at the time of death. And so again, that's going to depend on a number of things. How long they had been somewhere, did they change their address? Were they getting mail there? Intent to return or to stay. So that can be a little bit complicated again, so just be aware it's the county where they resided at death. The first step for the probate process to kind of get the ball rolling is to gather up the information that you may need and see what you're missing. And so here's just a rough list of the things that you would need to have. The flight plan. We're going to learn what that is here in a few minutes. You're going to need the original will. So you don't want to have a copy. You need to find the actual original of the will. You need to have information about life insurance policies, bank accounts, deeds, and you're going to have a death certificate. So kind of the very earliest you could try to start the probate process is likely going to be after you've obtained the death certificate. So if we look at the process itself, what's going to happen is somebody's going to file an application for probate. And again, you'll file that in the court in that county where the person resided. Once that application has been filed, there'll be a 2-week waiting period before they'll set a hearing on the application. All right? At that hearing, that's where they're going to decide whether or not there was a valid will. They're going to decide who they're going to appoint to be the administrator or the executor of the estate. Okay? So before that hearing happens, during that 2-week waiting period, the county clerk's going to post a notice to anyone who may want to contest the will. So if you think that there's a newer version of a will, or if somebody thinks, that this will was forgery or whatever, if there's going to be that kind of contest, that will be raised there. Now, it could come up later as well, but it's specifically sort of notice is given for people to make that objection then. At that point, there's going to be an administration opened, and there's going to be a hearing held that's going to declare the death of the person, verify the existence of a will, appoint the executor, and issue what's called letters testamentary. And so what those letters testamentary do, they essentially say, Tiffany is going to be the executor of this estate, and she has the authority to act. So we'll talk about this in a little bit, but keep in mind, when someone dies, any power of attorney they had before that is irrelevant, right? The power of attorney ends at the person's death, and so no one can really act on that person's behalf or on behalf of the estate until they get these letters testamentary. After that hearing, when the executor gets appointed, they're going to have 90 days to prepare an inventory of the assets. Alternatively, they could file what's called an affidavit in lieu of inventory if they're not going to file that. But that, again, that's something you'd want to visit with an attorney to determine when you do that or not. The executor of the estate is going to notify all the beneficiaries under the will, and they're going to notify all of the creditors. Okay, so again, that's what happens if we have a will. If we don't have a will at that hearing, before any of this can happen with an inventory or notifying beneficiaries or anything like that, then we have to have that heirship proceeding I mentioned earlier. They will have to appoint a attorney ad litem to represent the estate, and they will conduct research to determine who the heirs are. And I know that can be really frustrating, especially if you're thinking, everybody in town knows who the heirs are, right? He had 3 kids. Why are we doing this? It's part of the process. And again, this is why it's so important to have a will, because you want to avoid all of this rigmarole that has to happen before you even get to the probate process. If a contest is filed, in other words, if somebody wants to claim something is wrong with the will, either it's forged or it was undue influence or the person didn't have the testamentary capacity to make a will, that can then be handled within the probate process. So those challenges may be heard there. After all the debts have been handled, any of the will contests have been resolved, then the remaining assets will be distributed to the beneficiaries under the will, right? Or if there's no will, in line with those intestate succession procedures that we talked about earlier. So that's sort of how the process flows as far as probate goes. There's a really helpful infographic that there's a law firm here in Texas put together. This just sort of shows you the flow of how all of this works. And it might be worth taking a look at if you're a visual person, especially, to sort of walk you through how the process plays out. Now, in Texas, there are a few alternatives to the probate process that I want to make sure that we at least discuss and you're aware of. So this would be if somebody dies and there are certain circumstances present, you may be able to get their assets transferred without having to go through the formal probate process. This won't work for everybody, but there are at least instances where this might be an option. If the person died with a will, there are 2 options. The first one's called a muniment of title, and the second one is called an affidavit of heirship with the will attached. If they died without a will, there are also 2 options. It's called the small estate affidavit, and then just an affidavit of heirship that obviously wouldn't have a will to attach. All right, so let's talk through these different types of probate alternatives. The muniment of title is something that I don't know if it's only Texas that has it. It's rare to see, so it may just be a Texas-specific statute. It's basically the express lane probate is what one of my probate lawyer friends calls this. So it's similar to probate. It's just way less expensive, it's less formal, and you can move through it faster. All right? You're going to have a written will for a muniment of title to be an option. The estate cannot have any debts other than debts that are secured by a real estate lien. So you can look at the estate pretty easily and tell, did we owe money on anything but the land, right? If the answer is yes, muniment of title probably is not going to be an option, okay? But if the answer is no, if they had no debt or the only debt they had was secured by a real estate loan, then muniment of title could still be a potential option. One other thing to note here, sometimes you'll see somebody who maybe didn't have any debt, but they had a credit card with a couple $1,000s on it. That's a situation where you could probably go ahead and pay that off, then they wouldn't have that debt, and this may come back into play as an option. So just keep that in mind there. The real intent for this and when it's useful is if you just need to simply transfer title of property from person A to person B. So again, for a real complex estate, this isn't going to work. But if you've got a situation where there's just a piece of land or there's a house and really all you've got to do is get that name switched, this may be an option. In this sort of express lane probate, they're not going to appoint an executor. There's not going to be any additional filings. There's essentially the court's going to just hold a hearing on the property transfer, and the court will issue an order, and that order is sufficient for the county clerk and the deed records to transfer title from person A to person B. So certainly an option, cheaper, faster than probate. So be aware that that's something you might look into in the right circumstances. The next one I want to talk about is called the small estate affidavit. This is an option that does not require a will. So if someone dies intestate, you might look at the small estate affidavit as an alternative to the probate process. This one's pretty limited, though, in situations where it would apply, and frankly, for most rural families, it's probably not going to be an option. The estate value has to be less than $75,000 at the date of application. All right? There are a few exemptions that you don't count when you're adding up the value of the estate. You don't count the homestead. For an urban homestead, that's going to be up to 10 acres of land and improvements. For a rural homestead, that can be up to 200 acres for a family. There's also some exempt personal property that's listed in the statute. There's a number of things listed. A vehicle, there's, I think, 2 guns. There's certain things there you don't count. It can be up to $50,000 for a single person, $100,000 for a family. So it's $75,000, but you don't count everything, all right? Here's the other kicker. It's only an option if the homestead is the only real property owned, okay? And it will be inherited only by the spouse or minor children. So again, that's pretty limited, right? For most farm families, they probably own land besides just the homestead. They may not necessarily be leaving it only to a spouse or to minor children. So beware that it's an option. Also beware that it's fairly limited in when it can work. The other thing here is the homestead is the only real property that the small estate affidavit can transfer. And that makes sense because that's the only real property you could own. So our third option is going to be an affidavit of heirship. And this one's an option whether you have a will or not. If you have a will, you would attach it to the affidavit. That would really be the only difference. So essentially, an affidavit of heirship is just a legal affidavit that someone prepares and signs, and it needs to be somebody who has knowledge regarding the property of the decedent and who the heirs are. Now, this can't be one of the heirs, right? You can't use somebody who's going to inherit. It would just need to be a third person who's not involved in the estate at all that has that type of knowledge. They would essentially prepare an affidavit that just lays out, here's the person's assets, here's the person's heirs. It would be filed with the county clerk. So instead of going to the court and filing something in the court with the judge, filed in the clerk's office, there's not a hearing that is held, and this would be sufficient, again, to give you the authority to transfer ownership of that property. There are a few situations where this won't work. One of those is you can't use if there are unknown heirs or a potential disagreement between heirs regarding the estate. So if there's an argument about who owned what or who should receive what or what dad owned, that's not going to be an option. There are some financial institutions that may not accept this to transfer assets. So for example, if you've got an account at Wells Fargo, right, or some national bank that you need to transfer, they may not accept an affidavit of heirship. They may require you to actually go through the probate and get the letters testamentary to take that action. And the other thing is it's probably only, or at least the most useful in situations where real property is the only probate asset. And again, that's similar to that small estate affidavit in that this just gives you the authority to transfer one person's name for another's on that deed for the property. So again, those are kind of some alternative options. They may fit really well in your situation, but they're limited into what they can do in the situations that they can apply in. So just be aware that they exist. It certainly might be something to talk about an attorney with prior to going ahead and filing a probate to see if one of those alternative options might be available.